So this is the session on online intermediary liability or immunity. I'm going to hold introductions to a minimum so we have maximum time. Each will take 15 minutes. We'll try to respond to each other briefly, and then we'll leave time for folks to participate from the audience. I'm Paul Levy. To my immediate right is Maria Speth, who is probably the leading Section 230 litigator in the country. Her record defending rip-off recording liability is legendary in the field. I don't know if she has any enemies in the room, but she has many in the country. Gavin Sutter is a professor of law at Queen Mary Law School at the University of London. Gavin has a somewhat different perspective from the rest of us, and I'm very indebted to him for being willing to share that perspective. It was hard to find, I confess, somebody who was willing to come to CFP and express this perspective. And finally, on my left is Eric Goldman, who is unquestionably the leading academic authority in the United States on Section 230. He teaches at the Santa Clara University Law School and runs the High-Tech Institute there. We're going to start with Maria, then go to Eric, and then Gavin, and then me.
Do I have any enemies in the room? I know last time I did one of these presentations, I had a couple. I was waiting for the little questions to go out first. Okay, so I'm going to cover the basics and then some of the policy issues and let these guys deal with the more in-depth policy issues. Can everybody hear me okay? Yes. All right. So, as you know, 47 U.S.C. Section 230 governs interactive websites and specifically addresses user-generated content. It protects websites like blogs, consumer review sites, which is where I've done most of my work is in consumer review websites, classified ad sites like the Craigslist, marketplaces like eBay, and social media like Facebook. The overall effect and purpose of Section 230, of course, is to limit website operator liability and ISP liability. It fosters free speech, and I think an important thing to point out is it's a significant departure from the rules that were in place with print publications. And that makes it difficult for practitioners to really wrap their arms around, because what I get a lot, very often, is I get practitioners who, maybe have been practicing a long time, maybe are quite experienced in the defamation field, and they know from their work in defamation that if the publisher publishes it, the publisher can be liable. And so we continue to get demand letters from from practitioners who take the position that you are a publisher and therefore you are responsible, and will even cite classic defamation law. Of course, when we get into the online world, it's a very, very substantial departure from that. And when we educate the practitioners and say, well, it's different, there's no liability here, sometimes we get a gasp, a shock. You're telling me your position is your client's not responsible, even if they refuse to take it down when we ask them to. And that's what we're going to talk about today, so that interaction, that policy issue. The kinds of activities that are protected are claims for defamation is probably the one that I see the most, but there are many others as well. The web operator is protected in editorial functions. And so it's not a complete hands-off approach. That was not the intent of Section 230. It is perfectly okay for the web operator, for instance, to edit the content in the sense of removing defamatory comments, removing pornography, removing anything that the web operator or the ISP, for that matter, feels is offensive. And that will not affect their immunity under Section 230. And again, the refusal to remove content, even with knowledge that it is false, does not affect immunity under Section 230. Probably the most controversial portion of Section 230 that we run into is the injunctive relief issue. So it's not just, let me go to the big picture here. The statute says no provider or user of an interactive computer service can be treated as a publisher or speaker of any information authored by a third party. It doesn't say you can't get damages against them. It says you can't treat them as a publisher or a speaker. And it's been very, very broadly interpreted to say that it's basically an immunity from suit, which means it's an immunity from injunctive relief. The reason that becomes the most controversial portion of the statute or issue is that the argument is that there's no remedy, and I think we're probably here today from Gavin on that issue. So the proponents of, or the opponents of the CDA take the position that, well, if I or my client have been defamed on your client's website and your client is not legally obligated to take it down, then my remedy against the author, which is there, doesn't do me a lot of good because the posting continues to be there and continues to harm me. And virtually every court, not virtually, every court that I have been involved in that's looked at this issue has said that it does extend to injunctive relief. And the policy behind that is really actually quite simple. If web operators had to defend injunctive relief lawsuits, even if there was no claims for liability on a regular basis, they would essentially, either be out of business or expend an enormous amount of funds doing so, because they would constantly be sued. Or if they didn't want to spend a lot of money defending those lawsuits, they would have to have a policy which had them take it down anytime a lawsuit was filed in order to avoid the litigation, which of course would be a chilling effect on the First Amendment, because they don't want to spend the money and therefore they just pull it down. So the injunctive relief remedy, or the injunctive relief immunity, becomes a very important part, while controversial, a very important part of the protection of the First Amendment rights. I want to talk a little bit about activities that are not protected, however. Clearly, the CDA does not, Section 230 does not cover content generated by the web operator or the agents of the web operator. It doesn't cover intellectual property claims. So if you've got a DMCA issue or a digital millennium copyright issue, if somebody's infringed your copyright, then the CDA simply will not come into play. You'll go through the DMCA process. It doesn't cover claims for trademark infringement. However, caution here. Trademark infringement must have a competitive injury. In other words, if your claim is really for defamation, but you know that you're not going to succeed on the defamation claim because of the Section 230, and you then couch it in terms of a claim for trademark infringement because you say that your client or your trademark has been infringed, you need to be a competitor. It needs to be a competitive injury. It's not enough that they used somebody's trademark. They have to use it in a way that is in a competitive market. Another interesting area that is not protected is what came out in the Ninth Circuit in the Fair Housing Council of San Fernando Valley versus Roommates case, a somewhat legendary opinion. And in that case, the court said, look, you can't induce users to create illegal content, in fact, require users to create illegal content and then claim CDA protection. And in that case, the form that you filled out in order to post your housing had discriminatory questions. So it's against the law to say, I'm only going to let you rent if you tell me what your race is. Well, that was one of the questions. How about your sexual preference? That was one of the questions. And that's not allowed to be asked. I can't, as a landlord, I couldn't ask that question if you knocked on my door, or if you called me, I can say, well, by the way, what race are you? By the way, what's your sexual preference? That would not be allowed. So no more wasn't allowed on a website, and the operators of the website actually set up the form that you had to answer those questions as part of posting your listing for housing. And the court said that's going too far. There, the operator, the web operator themselves, is violating the law, or at the very least inducing others to violate the law, and that's not going to be protected. Kind of brings me to a decision that was just rendered yesterday, in fact, by the Court of Appeals in New York, which is the highest court in New York. New York's a little backwards there. We start with the Supreme Court, New York's Court of Appeals. And that decision was interesting because and it's called Shamili. I don't even know if I'm pronouncing that right. I think I got that right? I'm going to say Shamili. And that was interesting because a third-party user sent in the content. Clearly, CDA immunity governs that. But the defendants in that case, the web operators, then reposted it on their own portion of the blog, added a heading to it, They, a little preface to it where they actually made comment on it. And they also added a picture to it that supported the defamatory statements argued. So that one of the defamatory statements was that the subject of the posting was a racist and was discriminating against Jewish people. And the operator of the website added a photo and used the face of the the subject, and then made it look like in Jesus clothing, and then just sort of added to the whole thing. And then there were some comments that were not defamatory, but were clearly playing into what was alleged to be defamatory. And on a motion to dismiss, which you take the pleadings to be true on their face, originally the Supreme Court said there's no CDA immunity. The appellate court said there was CDA immunity, and then the Court of Appeals affirmed that and said that there was CDA immunity over the entire case was thrown out, even though there was web operator generated content, because they said the web operator content was not in it of itself defamatory. Strong dissent in that case, though. There's a split. There's, I think, what is it, 3-4 split? Do I have that right? I'm not sure. Yeah, 3-4. And so strong dissent in that case, and it all comes down to to what extent did they add to the content. So also from a procedural perspective, there was some dispute for quite a while about whether or not the CDA was simply an affirmative defense that would be decided later in the case, or whether the CDA is, it needs to be decided, it's an immunity from suit, and it needs to be decided early in the case. And procedurally, most courts that have looked at the issue now have said that it is decided early in the case, that it is an immunity from suit. That was a little scary for a while, because I don't know if you guys remember the first fair housing decision before it was amended actually really hurt on that point, but then they actually retracted and changed that language. So the last issue goes into what my other panel members are going to be discussing. That's the policy issues. And I want to go back to the Shanili opinion real quick before I break, because I think it quotes, actually, it's not from the opinion, it actually quotes from the congressional background in Section 230. And what Congress said there is the internet offers a forum for a true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity. And that it has flourished to the benefit of all Americans with a minimum of government regulation. And it's the policy of the United States to preserve the vibrant and competitive free market that presently exists for the internet and other interactive computer services, unfettered by federal or state regulation. And I think that's what we really come down to. And I'll say this before I sort of pass the mic here, and that is, I believe, well, I know that websites like Ripoff Report would not exist if it wasn't for the CDA. They simply would not and could not exist. And I think some of the other websites that we all love and hold dear to our heart, I know a lot of people might say, well, that's a good thing, that's fine. But there's other websites where people would certainly not like it to live in a world if they didn't exist. I think that it would be very, very difficult to operate an eBay, a Facebook, a Craigslist, Yelp, with the consumer reports on Yelp, or even Amazon with consumer reviews if it wasn't for the CDA. At the very least, if they did exist, they would not, again, be as vibrant a marketplace, because there would clearly be a chilling of free speech. With that, I'll pass on to Eric, that will talk more about policy, I think.